Hello, my name is Danielle Garten.
And I'm Christina Sricka. We're both criminal trial attorneys at the Department of Justice Antitrust Division. Thank you for joining us for this presentation today.
We are here to provide some basic background information on criminal antitrust enforcement within the Department of Justice Antitrust Division. We'd like to tell you a little about who we are and what we do, with the goal of hopefully working together in the future should you identify a potential matter or fact pattern that may be relevant to the work we do.
We collaborate and work closely with our law enforcement partners, inspectors general, and others within various offices and fields to help identify and prosecute violations of criminal antitrust laws.
This email is illustrative of the types of cases inspector generals and other sources often bring us. Antitrust cartels typically elicit a vision of executives sitting in a smoke-filled room, exchanging pricing information or dividing up a map. It does happen that way on occasion, but most of the time it's much more discreet and nuanced and may require a host of investigative techniques to ferret out and fully understand. They can be simple or complex, involving large companies or small, but there are a few guideposts that can help to determine if there might be a problem, some red flags if you will. We'll pause to give you a second to see if you can spot them, and then we'll discuss.
A few things to consider about this document. What is the relationship between the sender and the receiver?
Well, Christina, they appear to be horizontal competitors, which means competitors at the same level of distribution or sales. Criminal antitrust offenses require agreements between horizontally situated competitors. Why do you suppose the contracting officer wants 3 bids and wants to keep them under $1 million?
They are looking to avoid heightened scrutiny by keeping the bid numbers lower because higher cost bids generally generate more review and more scrutiny. They are also trying to create the appearance of competition. Assuming the sender is planning to win this business, what does the recipient of the email get out of it?
Well, these are iterative crimes, and there's always a quid pro quo. People don't enter into agreements unless they will benefit in some way. Sometimes this takes a while for everyone to receive their benefit. Therefore, as we'll continue to note, it is unlikely this is an isolated incident. We're typically investigating long-term criminal practices.
Also, while we focus on horizontal agreements between competitors, the contracting officer in this example, here Melissa, is still a problem and could also have criminal exposure. What are some of the costs of collusion and why does it matter? Well, antitrust offenses generally result in consumers being overcharged and defrauded, substantial financial harm, and a large number of victims. Conspiracies may be lengthy in time and effect, and conduct often spreads to other goods and services. We will now discuss a little bit about what the Antitrust Division does and how it's organized, provide some general background on what exactly constitutes a criminal antitrust violation, criminal antitrust enforcement, and go through some tips and red flags to help you identify potential violations in your everyday work. The Antitrust Division's mission is the promotion and maintenance of competition in the American economy.
The Antitrust Division is made up of 2 parts, the criminal sections and civil sections. The civil sections focus on merger enforcement and other non-criminal conduct. The criminal sections, which will be the focus of today's presentation, have approximately 100 attorneys located around the country in 5 sections. Antitrust criminal enforcement attorneys partner up with a variety of agencies, including the Federal Bureau of Investigation, United States Postal Service, the Department of Defense, the Department of Transportation, the Internal Revenue Service, United States Attorney's offices, among others. Antitrust prosecutors are located in Washington, D.C., Chicago, New York, and San Francisco. Case responsibilities are generally divided based on geography, although if a case comes from an area outside of the office's assigned jurisdiction, it may be transferred to another office or kept by the receiving office. The entirety of criminal antitrust law originates from a single sentence found in 15 U.S.C. Section 1, which is also known as the Sherman Act. Every contract, combination in the form of trust or otherwise, or conspiracy and restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. Criminal prosecution of Sherman Act violations is authorized by the Antitrust Division of the Department of Justice. Violations of criminal antitrust laws result in significant fines and jail time for individuals. This includes incarceration for up to 10 years for individuals and fines of up to $100 million or twice the gain or loss for corporations. The volume of commerce affected by the conspiracy drives the sentence for both individuals and corporations. In addition to criminal penalties, there are often other collateral effects as well. Restitution or compensation for injury or loss may be required to be paid back to victims. Civil lawsuits often follow criminal investigations and can result in treble damages. And because plea or conviction is based on beyond a reasonable doubt standard, debarment is often a foregone conclusion.
There are three main types of criminal antitrust violations: price-fixing agreements, bid-rigging agreements, and market allocation agreements. A single investigation or case may involve more than one type of these violations. We will discuss each of these violations in detail, but first, let's talk about the elements of a Sherman Act offense. As mentioned earlier, the essential element of a Section 1 violation is an agreement between horizontal competitors. To prove an agreement, the government must establish a meeting of the minds or mutual understanding between two or more independent business entities or individuals. The agreement can be established by direct or circumstantial evidence. An example of direct evidence would be the testimony of a co-conspirator that the defendants agreed to raise prices. An example of circumstantial evidence could be bids that establish a pattern of contracts being rotated among competitors, or telephone records showing calls between competitors on key dates. The government does not need a written agreement. A wink and a nod could be enough to establish a meeting of the minds. The government will also have to prove that the offense had an effect on interstate or foreign commerce, as well as an intent to agree. The government is not, however, required to prove loss or harm resulted from the agreement, that the agreement was successful, or that the co-conspirators had a specific intent to defraud. The Antitrust Division prosecutes both domestic and international cartels. International cartels tend to be broader in scope and larger in terms of affected volumes of commerce. The division has also successfully obtained jurisdiction over foreign national defendants. The Sherman Act applies to conspiracies involving import commerce. For example, conspiratorial transactions between foreign sellers and U.S. purchasers could be subject to U.S. antitrust enforcement. The Sherman Act does not apply to conspiracies involving exports or commerce between or within foreign nations absent meaningful effects on the United States. Antitrust offenses that are deemed per se violations cannot be justified under the law. Criminal violations of antitrust law are per se violations. Therefore, arguments or evidence that the agreed upon prices were reasonable, that the agreement was necessary to prevent or eliminate price cutting or fierce competition, or that the co-conspirators were merely trying to make sure that each got a fair share of the market are not defenses. However, note that the government cannot prosecute companies that make parallel, independent business decisions absent coordination or an agreement between them. For example, if the evidence shows that one company decided to take a pricing action on its own and its competitors each independently decided to follow suit without communicating their intentions to each other, this would not constitute a per se agreement subject to criminal antitrust enforcement.
Let's now discuss the three types of criminal antitrust violations. In price-fixing agreements, competitors agree to fix or otherwise determine the prices at which their products or services are sold. In short, price-fixing limits customers' choices. In a competitive market, we would expect customers to move from a seller who raises prices to a seller who doesn't. In a price-fixed market, the customer has no choice. Here's an example of price fixing. Competitor A says, "Will you agree to raise your price for salted peanuts to $1.99 a pound?" Competitor B responds, "Yes, let's raise the price at noon tomorrow." In a bid rigging conspiracy, competitors agree in advance who will submit the winning bid on a contract that a public or private entity wants to award through either a formal or informal competitive bidding process. In other words, competitors agree to eliminate competition for some piece of defined business, whether it be a sale, a contract, or a project. bid rigging basically predetermines a winner and eliminates competition. There are three common types of bid rigging. First, bid rotation or customer allocation. In bid rotation, all co-conspirators submit bids, but agree to take turns being the low bidder on a series of contracts. In allocation, conspirators each get dibs on particular customers, rather than just taking turns. This often takes the form of an agreement that all conspirators get to keep their current customers when those contracts come up for renewal. In complementary bidding, co-conspirators are likely to submit cover bids, which are intentionally high or intentionally fail to meet all of the bid requirements in order to purposefully lose a contract. Comp bids, as they're commonly called, are designed to give the appearance of competition. Value for competitors is that others will return the favor when it's their turn to win the business. In bid suppression, one or more competitors agree not to bid or withdraw a previously submitted bid so that a designated bidder will win. In return, the non-bidder may receive a subcontract or payoff. This is a simple illustration of how a bid rotation may work. Any company can initiate a communication about an upcoming bid, such as, I'm about to submit my bid for this business and I want to make sure you win it. What should I bid? What are you going to bid? Note that subcontracting arrangements are often part of a bid rigging scheme. Competitors who agree not to bid or submit a losing bid frequently receive cash payments, subcontracts, or supply contracts in exchange. Purchasing agents might also receive payoffs to make sure that a bid rigging conspiracy is unreported. A purchasing agent might even be the originator of a conspiracy due to their role in the procurement process. Evidence of such payoffs can be very persuasive for a jury. Here's an example of a cover bid. Bidder 1 states, I'd like to win the bid to demolish the Water Street Bridge. If I get the job for $850,000, I can make some good money. Can you submit a bid above mine? Bidder 2 responds, sure, I'll come in at $900,000 if you let me have the next one. And bidder 1 says, okay, I'll plan on it. There's always a quid pro quo, and these are iterative crimes that may be long-term propositions. If someone is willing to go high on a bid today, it's because they expect to recoup tomorrow. So it may take some time for an entire scheme to be seen. Participants can decide who wins a particular contract using several forms of allocation standards.
Here are a few red flags to look for in the bid rigging context. A rotation of winning bids among competitors or competitors taking turns winning contracts. The same firm wins bids over time. A losing firm receives a subcontract award from the contract winner, or the bid prices for all companies suddenly increase without explanation. Similarities in the actual bids or the metadata for bids submitted electronically may indicate that all of the bids were prepared by a designated winner. One example of this are bids containing the same typos. And finally, statements by the bidders that a bid was a courtesy, complimentary, token, or even cover bid.
Here's an example of bid suppression. All companies end up winning the same amount of work over a series of bids and over the course of time. In an allocation agreement, co-conspirators agree to divide up customers or geographic areas. The result is that the co-conspirators will not bid or will submit only complimentary bids when a solicitation for bids is made by a customer or in an area not assigned to them. This scheme is most commonly found in the service sector and may involve quoted prices for services as opposed to bids.
Be on the lookout for situations in which the same company seems to get business over and over again, and competitors never seem to challenge or solicit the work for themselves. Look for anything that makes it obvious that companies that should want the business aren't seeking it. In other words, someone giving up a business opportunity for which they're otherwise obviously qualified. There are some red flags to look for in the allocation scenario too. For example, competitors who suddenly stop selling in a certain territory or to certain customers, a competitor referring customers to another competitor, and a salesperson or prospective bidder saying that a particular customer or contract belongs to a certain competitor.
Here's an example of geographic allocation. Certain companies only submit bids in certain geographical areas.
As you can see from the following chart, The number of corporations and individuals charged with criminal antitrust offenses has been significant over the years. Over the last decade alone, the Antitrust Division has obtained billions of dollars in criminal fines and significant custodial sentences for individual executives convicted of Section 1 violations and related offenses. The Antitrust Division's leniency policy allows companies and individuals involved in antitrust crimes to self-report and avoid criminal convictions and resulting fines and incarceration. The first corporate and/or individual co-conspirator to confess participation in an antitrust conspiracy, fully cooperate with the Antitrust Division, and meet additional conditions that are set forth in the Division's written leniency policy will receive immunity for the reported antitrust crime. The benefits of being admitted to the program can provide substantial incentives to cooperate for those with inside knowledge of the conspiracy. Leniency may be available both before or after an investigation has started. This creates a race to be the first to report.
Detecting antitrust violations. We'll discuss favorable conditions for collusion, bid patterns, warning signs in pricing, and suspicious statements and conduct. While it can happen in any industry, there are some industries where collusion is more likely to occur. Let's discuss a few examples. In markets with fewer sellers or a limited number of qualified bidders, it may be easier for the competitors to coordinate. Increased barriers to entry, such as high startup costs or heavily regulated industries, can create an environment ripe for collusion. Products for which there are few substitutes or standardized products may also be easy targets for collusion. Trade shows and industry conferences present opportunities for competitors to easily communicate and coordinate. Similarly, when employees move between competing companies, they can use their contacts to maintain or begin collusive discussions. Generally speaking, collusion occurs in markets with stable products and long-term competitors.
When investigating, there is a value in looking closely at even the most basic facts. Two examples of simple mistakes that can be easy to overlook may include similar typos or other errors in competing bids, or one competitor obtaining or submitting bid materials on behalf of multiple companies. An older but still valuable example of a simple but yet important mistake are these stamps that appeared on separate bids from two separate competitors. What do you notice about these? Well, they came from the same stamp roll. Does this show that there was an agreement between the competitors? Likely not, but it can be powerful evidence to a jury. Here is another example of a simple but important mistake. These are cover letters that were submitted from two competitors in response to the same request for proposal. What do you notice about these, Danielle?
Well, Christina, at first glance, I noticed that there are similar typos in both cover letters. Please give us a call if you have any questions. Considering these came from two competitors, I would consider this a red flag.
I think you're right about that, Danielle. Sometimes indications of collusion may appear in the simplest of areas, and a careful eye can spot red flags such as sloppy work by vendors. Similar applications focusing on handwriting, typeface, stationery, typos, mathematical errors, last-minute changes, whiteout, or physical alterations on bids. Vendor picks up an extra bid package for another vendor or submits a competing vendor's bid. The same metadata and IP addresses for bids that are supposedly submitted by different competitors. This slide provides some examples of suspicious bid patterns. Other examples include identical or similar bids submitted by different companies. A pattern of collusion often takes time to emerge, so keep looking closely. A real case example from the Antitrust Division involved collusion on school bus routes in Puerto Rico. In that case, local school bus services were provided in part by private companies. Federal grants from the Department of Education paid for bus service in low-resource areas, among others. School bus bidding occurred every few years, and the request for proposal was by route. Once the RFP was issued, school bus companies would meet at the community center before the bids were due and divided up who would win each route. They would also decide who would be the secondary or complementary bidder and agreed on bid pricing. The government had recordings, phone calls, and witness testimony, among other evidence. The case resulted in 4 individuals being convicted of Sherman Act and mail fraud offenses and receiving sentences in excess of 12 months.
Warning signs might also arise in pricing, which may include sudden and identical increases in price or price ranges that cannot be explained by cost increases, anticipated discounts or rebates that disappear unexpectedly, similar transportation costs specified by local and non-local companies, and attempts to shop around by customers being stonewalled by their suppliers.
The Federal Acquisition Regulation, also known as the FAR, provides that bidders must certify that their bids are independent. From an enforcement standpoint, this is very helpful because bidders are on notice that they have to submit independent bids. Colluding on bids would not only run afoul of the Sherman Act, but would also reflect a false certification under the FAR. False certifications may serve as the basis for the material misrepresentation required to prove a wire fraud charge.
In addition to market conditions, competitors may make statements that raise concerns. These may include a customer or territory belongs to a certain supplier, references to respecting customers or territories of competitors, references to courtesy bids or throwing in a number, use of same terminology or rationales by companies when explaining price increases, or statements indicating advanced knowledge of a competitor's pricing.
Here are some other examples of conduct and behavior that could indicate collusive conduct. Companies meet privately before bids or submit bids for work they cannot perform. Bids contain last-minute changes. Procurement officials who regularly forego the competitive bidding process for emergency work. Invoicing for work awarded contains charges for consulting work when consulting work is not required. Procurement officials who are associated with consulting vendors. For additional information, please refer to the Antitrust Division's website.
Thanks for joining us. We hope you found today's presentation useful. In the event you encounter conduct that you believe may constitute a criminal antitrust offense, please contact the Antitrust Division Citizen Complaint Center or any of our criminal sections.